Okay. Hello, you're all very welcome to the 6th annual webinar of What's Market for Commercial Contracts. For those who don't know you, my name is Mark Fry. I'm a partner with the Mason Hayes & Curran Data and Technology team. And presenting with me today will be Caoimhe Ruan, who's a Senior Associate also on our Data and Technology team. So at the outset, I would like to flag that this webinar is being recorded and also that the slides will be available afterwards. So please don't worry about taking down all the detail from the slides as we go through the presentation. So next slide, please. So what do we mean by what's market? So for the last couple of years at Mason Hayes & Curran, we've been tracking the main clauses in a wide range of contracts, whether it's a software license agreement, facilities management agreement, distribution agreement, or an IT outsourcing. There's always a handful of clauses found in all these types of contracts that most often give rise to the trickiest negotiations. And clients will often ask us, what's a reasonable position for us to take on these provisions? In particular, we're often asked about liability caps or what's a common market practice around the giving or getting of contractual indemnities. So we complement our internal MHC know-how with a survey each year of in-house counsel, asking you what your experience and your practice is to get a fuller picture on establishing with more accuracy what is market standard. So for this, our 6th annual survey with an even higher response rate than last year, we're able to identify shifts in the market practice, but we also see, I think it's fair to say, a remarkable consistency on some topics from year to year. And so before we go any further, I'd like to say a big thank you to all the counsel who responded. We really do appreciate you taking the time to work through the questions. The fact that we've received the highest number of responses to date this year really does help us to establish with more accuracy what is market. We're very happy to share the results of this 6th annual survey with you today and to highlight some trends against previous year's data. So the topics that we're going to look at today are, firstly, liability caps. We'll consider the types of caps, the size and levels of caps. We'll also look at carve-outs from the liability caps and or super caps for particular risks. We'll then turn to indemnities and look at exclusions of liabilities. We're also then going to look at a couple of topical issues, including AI from the contracting perspective, ESG, governing law, electronic signatures, dispute resolution, and then finally we're going to touch briefly upon some regulatory issues, including DORA and the impacts on contracts. So we'll highlight and reflect on a couple of trends in these topics that we see coming through from the survey results and from our own practice. So do please feel free to ask questions. You can put them in the Q&A function on your screen and we'll do our best to answer those at the end. We're aiming to have about 10 minutes for Q&A for anyone who can stay on past the hour mark. So I'll firstly hand you over to Caoimhe, who's going to tell us a little bit more about who responded to the survey. Caoimhe, over to you.
Thanks, Mark. Next slide, please. Yes, so we had an increased response to this year's survey than previous years, and respondents were spread across a number of different industries. You can see on the slide there that the most popular number of respondents came from financial services and the tech sectors. You can also see that we had quite a number of responses from the energy and built environment sectors. And then also you can see that this year, most survey participants, well, the majority came from the customer side, about 52%, with about 48% coming from the supplier side. And just finally to add as well that most of our survey participants were in the private sector, about 79%, and about 21% are from the public sector. And just to flag for the rest of today's webinar, we are using a colour coding system. Green is for customers and blue will be for suppliers. Okay, so Mark, turning back to you to kick us off on liability and caps.
Thanks, Caoimhe. So I think it's fair to say a broad variety of industries has responded to the survey, but the one issue that really we all have in common and that takes the most negotiation, irrespective of what industry you're in, really is the issue of liability. And that's the first part of our survey. And the responses to the survey show that really the vast majority of respondents, both suppliers and customers, both green and blue in the data here, routinely include liability caps. So the data shows us that mutual caps are still a lot more commonly sought by suppliers. We've had 55% of suppliers indicating that they routinely include a mutual cap on liability. That's up from 47% last year. Less suppliers saying that they only include caps for their own interest at 33%. And not surprisingly, suppliers more often have caps in contracts as a matter of routine, with only 12% leaving it for negotiation. From a customer's perspective, you can see that 38% say they wouldn't agree a mutual cap, instead would include a cap to protect their own interest. That's up slightly from previous years, but I think for higher risk and higher value contracts, for example, large IT outsourcing agreements, it's probably fair to say that we generally see a far higher portion of customers seeking to include caps and liability to protect their own interests only. Customers in those types of high risk arrangements will rarely agree that they should have the same or an equivalent level of liability as the supplier. You can't equate the risk, where a customer's main responsibility is very often just to pay the fees. A decreased percentage of customers, only 22%, will leave liability for negotiation. Next slide, please. So what are the types of liability caps and how are they generally structured? What is the approach that suppliers and customers most commonly take to liability caps? So firstly, dealing with suppliers, you can see that the most frequent approaches for suppliers, significant number, 36% have indicated that they look to cap liability at a fixed monetary amount. That largely aligns with data we had from 2024, 2023. It's overall lower than what we saw in previous years. So it was back in 2021, 2022, it was actually a much higher figure. So for suppliers, there's certainly a lot of merit in fixing monetary amounts, as it does create certainty. 34% of suppliers look to cap their liability at total contract value. Again, largely in line with recent years. So 2024, 36% indicated they took that approach, but it's still much higher than we would have had in much further years ago. So back in 2021, 2022, we had only about 26% of suppliers indicating they took that approach. But nearly half of suppliers indicated they would cap their liability at the equivalent of or multiples of annual fees. So 30% plus 16%, as you can see there from the data. So that data really does back up what we do see in practice, and that is that most suppliers generally want to limit their liability to what they're getting paid. They'll carefully consider their insurance requirements, but ultimately they'll look at the risk versus reward scenario. So looking at the data from customers on the same slide, you see that the data shows that most customers are now accepting caps based on multiples of annual fees or value, 19% plus 17%. So overall, we've seen a long-term trend of more and more customers indicating that they'll accept caps at a multiple of fees or value. One trend that we do tend to see when acting for customers, particularly those customers in the financial services sector or in the technology sector where they might have good bargaining power, is to look for the best of both worlds approach, so that we see them looking to link in a cap on liability to the higher of either a fixed amount or a multiple of fees. What that level of cap will be obviously varies from contract to contract, and the subject matter, the value, the risk, and it will be depending on the bargaining position of the parties. Suppliers, in practice, we tend to see them having a lot stronger bargaining power in certain sectors, including cloud computing, or for those of you who are more recently looking at AI procurement and generative artificial intelligence. And in the alternative, where customers have bespoke contracts, so they're not contracting on the basis of a supplier's standard terms, we do tend to see them having a higher scope for higher caps in those types of arrangements. So next slide, please. So where you typically agree a cap as a multiple of the contract fee, what multiples do you typically use? So as we've seen from the data in the previous slides, an increasing number of suppliers will agree to a cap based on a multiple of fees, but where it is based on multiple, what's the quantum, what's the amount most commonly used? So the approach from suppliers, and the survey results shows that 45% have indicated that's typically 1 to 2 times fees. Now, that's down quite a bit from what we would have seen in previous years. So back in 2021, for example, we had 69% of suppliers indicating it would be at 1 to 2 times fees, but it is similar to what we've seen in more recent years. So it aligns with data from last year where it was 48%. 18% of suppliers indicated that they would typically use 3 to 4 times fees. That's similar again to what we saw in previous years, and that data hasn't really changed much. It's always been around the 18 to 20% range. I think it was 22% in 2021, 22% in 2024, thereabouts. But one of the biggest shifts that we've seen over the years, and this is reflected in this year's survey again, is the reduction in the number of suppliers that have indicated they would typically agree a cap based on more than 5 times the contract fee. So back in 2021, 2020, we had over 18% of suppliers indicating they typically agree caps at more than 5 times the contract fees. That figure has dropped significantly over the years. It dropped in 2022, 2023, and that trend has continued from this year's data. So now only 4% of suppliers, a significant drop, have indicated they would agree caps at that level. So quite clearly, there's a much more cautious approach taken by suppliers with regards to liability caps. Looking at the customer's approach, the data shows us that a lot of customers are getting comfortable with general liability caps linked to 1 to 2 times fees. 46% have indicated in this year's survey they typically use that level. It can often be a challenge for customers to get suppliers to agree general liability caps of more than 2 times fees, but about 24% of customers had indicated in this year's survey that that's typically the case for them. What we do see in our practice is where customers agree a general liability cap from the supplier, which is based on a relatively low multiple of the fees or a low fixed amount, that tends to only be where they have an appropriate carve out from this general liability cap for key risks. So, for example, they might have a higher super cap on liability for issues such as data protection or other risks. And there'll also usually be some risks for which the supplier is asked to take unlimited liability. And that brings us to the next part of our survey. Next slide, please. So for these slides on special caps, carve-outs, and indemnities, we're going to be presenting the data for the suppliers and customers separately. So we deal first with the data for the suppliers. So we asked suppliers, do you apply a separate cap, lower, higher, or uncapped for any of the following: data protection, confidentiality, IP, defective products, property damage, and indemnities generally? So the data for data protection here shows a clear trend that most suppliers, 60%, will agree super caps for data protection. So in previous years, we would have seen a lot more suppliers indicating they would agree uncapped liability for data protection. And this year, there's still a high proportion, so 38% of suppliers did still indicate that they would agree uncapped for data protection, but we expect that's mainly in areas where there isn't a significant processing of personal data or a significant risk to the supplier. The survey results do show us that it's a lot more common to see uncapped liability for issues such as confidentiality and third-party IP infringement, but there's also a clear trend to note here for confidentiality. So we are seeing a downward trend. About half of the suppliers, 50%, indicated they would accept uncapped for confidentiality, but that's down from previous years. So if you go back to the early days of our survey, we had over excess of 60% indicating they'd agreed uncapped for confidentiality. And we think that one of the key reasons for this trend is the concern that suppliers have about claims for confidentiality essentially being used as a backdoor for claims of breaches of data protection obligations or breaches of data security. And it's now a lot more common that where you do have uncapped liability for confidentiality agreed, for suppliers to want to clearly include wording to call out that this doesn't mean there's also uncapped liability for disclosure of personal data or for data breaches. For third-party IP infringement, we can see that 66% of suppliers have indicated they would apply uncapped liability for third-party IP infringement. Now, that largely does align with previous year's data. So in 2022 and 2023, we had an equivalent number, about 68% indicating they'd apply uncapped for third-party IP infringement. And that's generally expected, and we would say in practice is generally provided by suppliers where they're using their own proprietary IP. They're generally willing to stand over their own proprietary IP. There may be certain scenarios, for example, if a supplier is sub-licensing third-party IP to a customer where they don't want to take on uncapped liability, and they want to ensure that they can flow through any appropriate liability to their ultimate head licensor. And so in those scenarios, you may see them not agreeing to uncapped, but more having a cap on IP. So other areas for super caps, particular to certain sectors, we see liability for property damage and liability for defective products. Again, very much specific to certain sectors like the property industry. So dealing next with the customer feedback, on slide 11, please. So we asked, do you apply a separate cap, lower, higher, or uncapped for any of the following? So for confidentiality, again, you can see very much a trend here in line with what we've seen in the supplier side, that customers are, in the first instance, looking for uncapped liability, but that is down from previous years. So if you go back to the early years of our survey, we had over 80% of customers indicating they would typically apply uncapped liability for confidentiality. That's now down to only 59%. So a clear shift and a trend here with regards to confidentiality. For third-party IP, we've 67% of customers indicating they would typically agree uncapped for IP. Again, down slightly from previous years. And for data protection, 46% of customers indicated they would agree a super cap, with 58% indicating it's uncapped in practice. So again, a clear trend that we're seeing here from both the supplier and the customer side towards super caps for data protection losses. But in practice, where we do see uncapped liability for data protection, similar to suppliers, we would generally see that only in cases where there's a low risk for processing personal data and not in all large data processing arrangements. So the actual level of the data cap can vary quite a bit depending on the particular risks. Customers will be looking to what their exposure is, what are the claims, what are the potential fines. Interestingly, we have seen a lot more suppliers agreeing to higher data caps, but on the basis that a customer would pay them or reimburse them for the increased cost, for example, of their cyber insurance. That's certainly a trend we've noticed in a lot of recent transactions. Okay. And then if we look at the data in relation to indemnities, we have a number of suppliers and customers indicating that they would also give super caps for unlimited liability for indemnities generally. And it's important to consider what types of indemnities are common under most contracts. So suppliers will need to be aware that where an indemnity in a contract is provided, what does it cover? What is the scope of that indemnity? They want to make sure it's not overly broad, and they certainly want to make sure that they can flow down any indemnities to ultimately responsible third parties. So that brings us to the next part of our survey on indemnities, and I'll pass you back over to Caoimhe.
Thanks, Mark. Okay, so you can see we asked both our supplier and customer survey participants basically the same question. Which of the following indemnities in favor of a client or customer do you most commonly accept? And if you're the customer, which of the following indemnities in your favor do you most commonly request? So we had 5 options here. We have data protection, third-party IP breaches, property damage, personal injury caused by negligence, and TUPE indemnities. So first, as Mark already alluded to, I suppose if you're acting on the customer side, you're looking for as broad an indemnity as possible, trying to cover as many types of loss as possible. And then obviously, if you're acting on the supplier side, you're going to essentially be looking for the opposite. So firstly, you can see from this year's survey data, there's a notable increase in data protection indemnities on both the supplier and customer sides from previous years. The supplier side is up from 39% last year to 50% this year. And on the customer side is up from 69% last year to 77% this year. So a pretty big jump on both sides of that. Then turning to indemnities for third-party IP breaches. The data kind of shows us these are pretty standard year on year. You can see on the customer side, about 70% of customers will seek these from their suppliers. This is the same position as last year. It has slightly gone down for suppliers, though, from 75% last year to 68% this year. And as Mark already alluded to, the position on suppliers seeking these type of indemnities or agreeing to these type of indemnities is often determined by whether they're comfortable standing over their own proprietary IP. And then moving to indemnities for property damage, this increased on the supplier side this year from 24% to 30%, and went down for customers from previous years from 34% to 26%. These types of indemnities would obviously be more common in kind of construction type agreements or property agreements. Then the last 2 buckets, we have position on indemnities for personal injury caused by negligence and TUPE. The position on both is largely the same as last year. So I suppose, taking it back to speak about indemnities in general, it's quite a different legal principle to a breach of contract claim, and a lot will depend on the actual wording of the indemnity clause itself. It's all in how it's drafted. Case law does show us that the courts tend to look at the objective meaning of the clause and not the subjective meaning, i.e. what the parties thought it might meant or had intended it to mean. This means it's really important to be clear on what the indemnity says as regards issues like trigger events, or when the indemnity will kick in, as well as mitigation obligations on a party to perhaps try and mitigate their own losses. As Mark also alluded to, we are continuing to see instances of contract structures where you have back-to-back indemnities being flowed down to subcontractors and a range of suppliers. It's also important to be really clear in your drafting on whether any liability caps in your contracts will apply to the indemnities. It's important to look at the wording of both the indemnity clause and the liability clause together on whether the indemnity will be subject to the cap. It's also generally considered good practice to expressly call out a cap within the indemnity clause if it does apply, or at least cross-refer to the liability clause for the avoidance of doubt. I think now turning back to you, Mark, to discuss exclusions from liability.
So yeah, we might just keep on indemnities for a section. So just to sum up, I think, what are the key kind of takeaways from that data? So just back to the previous slide, please, indemnities. So I think, just one thing to keep in mind there is that it looks like there's kind of very much a close alignment if you look at the green and the blue for third-party IP, property damage, personal injury, and TUPE indemnities. So, for those types of issues, there's really not huge gaps between the suppliers and the customer positions on the types of indemnities that they're prepared to accept and look for. But the key variance here to note from this data is for data protection, where you can see 50% of suppliers and 77% of customers. So quite a clear, markedly higher portion of customers expecting an indemnity for data protection than suppliers that are usually offering it, although that gap is potentially narrowing. So that, bringing us up to the next area of our survey on exclusions. Next slide, please. So what's excluded? What types of losses will the supplier not be liable for? So we've asked, do you exclude liability or accept the exclusion of liability for certain types of indirect, special, or consequential loss? And the data shows us quite clearly, look, it's very much market practice for both suppliers and customers to routinely exclude liability for indirect or consequential loss. And that very much aligns with the common law principles that you'll all be familiar with, that parties can only recover damages that are reasonably within their contemplation at the time the contract was made, or which arise as a probable result of the breach. Where we do see a difference is that quite often we find that when it comes to the exclusion clauses, suppliers will often look to exclude a whole other raft of issues which may not necessarily be indirect or consequential. And this is backed up by data here, which shows that suppliers will routinely want to exclude loss of profits, loss of revenue, loss of anticipated savings, whether it's direct or indirect, and customers may want to push back on that. So one thing we would say is, just from a customer's perspective, be very careful about supplier standard exclusion clauses. They do often exclude a lot more than just indirect losses. And as a trend, what we often see customers looking to agree is a non-exhaustive list of indicative types of losses that are agreed between the parties at the outset to be direct and recoverable. And that overcomes that challenge further down the line of a supplier then turning around to say, well, look, these weren't within our contemplation at the time of the agreement, and they're therefore excluded as being indirect or too remote. So that's also a clear trend that we see. One other trend we might highlight with regards to exclusion clauses, and it wasn't asked in our survey, but just is over the issue of loss of data. Increasingly, for certain types of contracts, we do see a lot of suppliers looking to expressly exclude liability for loss of data. So that would comprise business or commercial data, and that can often be quite a contentious issue. And I suppose the key question that you'd need to ask in that scenario will depend on the scope of the agreed services. So who should take responsibility for loss and or corruption of data? From a supplier's perspective, if a customer were to lose access to critical data that's particularly business important or sensitive, that can create massive significant exposure for a supplier. So they'll ask themselves, is this level of exposure proportionate to the value of the goods and the services that we're providing under this particular arrangement? And for most arrangements, on the flip side, customers will say, we expect you to take responsibility for our data. We can limit your liability for loss of data, but we would certainly not agree to exclude it outright. So again, that's one of the many issues that we see as a trend, both suppliers and customers spending a lot more time on discussing and negotiating at the outset. So what is covered by an exclusion clause? And we'd always recommend that if the intent is to exclude a certain type of claim, such as wasted expenditure, agree at the outset what you mean by that and document it, ideally define it. So I'll now hand you back to Caoimhe, who's going to look at the next part of our survey, which I think deals with AI in the context of What's Market.
Thanks, Mark. Next slide, please. So turning to AI, which I'm sure is a very topical issue for most businesses at the moment, the question we asked our survey participants was whether they or their in-house legal teams have advised their organizations on using AI. As most of you probably expected, the use of AI in businesses and certainly advising on it has hugely increased on both the supplier and customer sides. We're seeing a very definitive trend towards the use of AI and advice being required from in-house legal teams on its use within their orgs. For example, if you look on the left-hand side of the slide, which is dealing with the suppliers, we can see that 54% of respondents have now at least advised on the use of AI or are already using it within their organizations. This compares to a much lower figure on the supplier side last year, when this figure was only 31%. Additionally, only 19% of supplier respondents said no, they've not advised on using AI, whereas this figure last year was much bigger at 37%. Then looking at the customer side, we can see that 29% of customer respondents have advised their in-house legal teams or are already using it, with another 29% considering using it. Only 32% have not yet advised on the use of AI within their organizations. And this is kind of consistent with the trend in the supplier side in that it's down from about 55% last year. Next slide, please. So we also asked our survey participants, which of the following are the top concerns for you or your organization when contracting to use AI? So you can see here, there's quite a bit of commonality between the supplier and customer sides. Each side's primary concern really is privacy. And indeed, in some of our survey participants' more detailed feedback, this came up a few times regarding security of personal data when using AI, along with a few other prevalent concerns like the accuracy of the AI output, potential inherent biases, and certain source materials used by AI systems. So I suppose comparing to previous years we ran our survey, we can see now that kind of supplier and customers' priorities are coming into focus. The picture this year is a lot more settled. Not surprisingly, there are, of course, concerns for liability of the output of the AI system. This has moved up the list on the supplier side to the second ranking this year, and it was down further down the list last year. This is ranking third on the customer side for the moment, with regulatory compliance just ahead of it. But we do expect this to move further up the list in the coming years, particularly as a lot of the supplier terms in the market for the use of AI systems and platforms would be very supplier friendly. So we can see customers kind of, concerns around liability for their outputs becoming higher in that regard. And customers should also be aware of those kind of provisions when considering the use and the risk of AI systems to their businesses. And then lastly, you can see on both sides that IP rights infringement issues are ranking in fourth for both at the moment anyway. I know we did ask our prompt question at the beginning of this webinar regarding whether attendees are using AI in their contract drafting. We will go back to that towards the end of the webinar. So we'll press pause on AI for now, and we will now turn to ESG issues. Next slide, please. And one more slide. Yeah, thank you. So the question we asked our survey participants on ESG: for suppliers, do your standard supply contracts commit your organization to ESG compliance obligations? And for our customers, do your standard purchase contracts include or take account of your ESG compliance obligations? And I suppose as many attendees today will be aware, ESG is very topical at the moment as well, particularly in respect of sustainability and governance generally. On the supplier side, we can see there's still a minority of 39%, which include commitments to ESG compliance obligations in their contracts, and 52 or 53% even saying no, they don't include those type of obligations. 52%, sorry, 53% is the customer side, and about 53% of customers actually do include ESG compliance obligations in their standard purchase contracts. So they are that bit more concerned about it. In looking, I suppose, in practice, we have observed there's kind of a relatively slow uptake on ESG compliance obligations forming part of companies' standard contracts. It tends to be more typically dealt with, certainly on the supplier side at least, in their perhaps codes of conduct or codes of practice, and you may see these sitting more adjacent to the contract. Having said that, you do sometimes see, them being included in the front end or at least attached as a schedule or an appendix to the standard contracts. So I suppose they are slowly becoming more popular and being turned into binding contractual obligations, but it's still been quite slow. And this, of course, could become less common in time. I suppose, given that EU level, there is a bit of rolling back of the red tape around ESG. For example, many of the corporate sustainability reporting directives obligations are now kind of only applicable to higher threshold organizations, and many SMEs will be exempt that would have previously fallen within its scope. We did ask one more question on ESG, so I'll turn to that on the next slide, please. Yep, so you can see here we asked our survey participants what the ESG areas of most concern to their organizations were. 8 different options, for example, ethics, health and safety, governance, other environmental matters, climate change, labor issues, the corporate sustainability reporting directive, and other. So we can see there's a bit of divergence between the supplier and customer sides here in terms of their priorities, with ethics ranking first for suppliers and governance ranking first for customers. Then we see ethics on the customer side is down at 5th. So there's quite a bit of divergence. Health and safety and then other environmental matters rank in the top 4 concerns for both sides. And climate change concerns also rank particularly high for customers. Interestingly, you can see that the corporate sustainability reporting directive is down pretty low on both sides, and this tallies with our earlier observation on the rolling back and the paring back of the ESG agenda and that directive kind of generally at an EU level. So that brings us to our next topic on the agenda today, and that is governing law clauses in commercial contracts. Next slide, please. So we asked our survey participants, when contracting with your international counterparts, how would you approach a contract that's governed by the laws of England and Wales? We have 3 options. Firstly, no change, not an issue, fine with the laws of England and Wales. Second option was insist on Irish law and jurisdiction. And the third was accept English law and jurisdiction, but adapt your contract to address specific Irish law related matters like data protection, for example. An interesting trend here that we've noticed from previous years is that suppliers have now overtaken customers as insisting on Irish law and jurisdiction to govern their commercial contracts. This is up at 46% for suppliers. They insist on Irish law, and that's up from 33% last year, which is a pretty big jump. And you can see that only 30%, 37% even of customers insist on Irish law. And that's down quite a bit from last year. It was about 50% last year, so quite a bit of 13% decrease. In line with this, customers now appear a good bit happier to simply accept English law governed contracts off the cuff, with no adaptations for specific Irish law related matters being made. You can see this in the no change, not an option no change, not an issue option. And that's gone up from 12% last year to 25% this year for customers. We don't know for sure, but we suspect that this is probably due to kind of the dust settling post-Brexit and concerns for customers post-Brexit being a bit more alleviated as time has gone on. Then lastly, looking at the percentage of customers and suppliers accepting English law, but adapting their contract to address specific Irish law matters, it stayed about the same as last year, 36% on the supplier side and 38% on the customer side. So I suppose, I know we were saying here that, there is an increase in Irish customers or being generally happy to go with English law supply governed contracts. In practice, we do see Irish law continuing to be used. And this is probably due to the global reach of Irish-based IT companies, which is spreading the practice of Irish governing law contracts being fairly widely accepted. So I think that brings us to our next topic, which is e-signatures. So turning back to you, Mark.
Thanks, Caoimhe. So for those of you who participated in the survey in previous years, you might recall that we asked a lot more questions around e-signatures, in particular types of e-signatures, frequency of use of e-signatures. This year, we've only really asked one question, and that's kind of focused on the use of what's known as qualified electronic signatures. So for those of you familiar with e-signatures, there's essentially three different types of electronic signatures that you can use. You can have a simple e-signature, you can have an advanced e-signature, or you can have what's the gold standard of e-signatures, what's known as a qualified electronic signature. So for most commercial contracts, day to day, they can be executed by using a simple electronic signature through an online platform like DocuSign or Adobe or otherwise. But QES is only a relatively new type of signature which was introduced to the market. And the data we had from previous year's survey showed that really only a minority of you were using a QES. But interestingly, there's been quite a significant uptake of you from this year's survey who've indicated that they are using qualified electronic signatures, which are, as I said, the gold standard. And this is particularly important because there are differing views in the Irish market about whether a simple electronic signature can actually be used to sign documents that need to be witnessed. And our view, it's shared by a number of other law firms, and I would stress is also backed up by a senior counsel opinion, is that if you are intending to execute documents electronically that need to be witnessed, you must use a qualified electronic signature to execute them electronically. And that's, I stress, where the documents need to be witnessed. It's only required where there's a strict need. Doesn't necessarily mean that you have to use it where you're witnessing a document for good practice or for evidentiary purposes. So the use of QES as a result of that is particularly important in certain sectors, such as property or the financial services sector, where you may more often use deeds for certain agreements. On to the next slide, please. So for those of you who indicated in your response to the survey that you haven't actually used a QES yet, a significantly higher portion of suppliers, you can see 39% have indicated that you expect to use them over the next 24 months. So that's something we're going to certainly keep track of in next year's survey. And I'll hand you back to Caoimhe and I for the next part of our survey on dispute resolution.
Thank you, Mark. Yes, so we had one question on dispute resolution in our survey this year, and that was, which of the following alternative dispute resolution mechanisms do you most commonly agree to in your commercial contracts? So as was the case last year, clauses that provide for a referral to mediation followed by arbitration is once again the most popular dispute resolution mechanism for both suppliers and customers. On the supplier side this year, however, no ADR, which is i.e. referring disputes straight to the courts, overtook arbitration as the second most common form of ADR mechanisms in contracts, with a slight increase to 29% this year from 26% last year. I suppose we can see a possible trend of supplier parties just being happier to go to the courts and possibly avoiding a lengthy and possibly time-consuming and expensive form of arbitration. We can see from the data on the slide, however, on the customer side, don't really go this route, with no ADR being the least popular option. They prefer to go to all other forms of dispute resolution prior to proceeding to the courts as the final option. So for customers, mediation followed by arbitration is the most popular there at 41%, followed by mediation at 27%, arbitration at 21%, and finally no ADR at 11%. So I think that brings us to our next topic, which is DORA, the Digital Operational Resilience Act. Next slide, please. So turning to another very topical issue in commercial contracts at the moment, we asked our survey participants, have you or their in-house legal teams considered whether DORA is applicable to them? With 4 options, the first being no, then yes, we are considering updates to our contracts. Yes, we have implemented DORA compliant contracts already. And then the final one as don't know. So I suppose just to flag that the topic of DORA is really important for our attendees that are working in the FS sector. DORA applies to a wide range of financial firms and also to certain critical businesses providing IT services to those financial firms. Coupled with this, the date for compliance with DORA was actually the 17th of January earlier this year. So as you may expect, turning now to the survey results, there's been a notable increase on both supplier and customer sides, confirming that, yes, they have implemented DORA compliant contracts. You can see on the supplier side, that's at 38%, which is up from 4% last year. And on the customer side, it's at 23%, and that's up from 3% last year. So I suppose just to kind of talk about DORA generally, we have seen quite an uptick in instructions from our clients on DORA. And we've been assisting many organizations with, the preparation and rolling out of contract addendums with DORA compliant clauses with their third-party suppliers, as well as advising other organizations on perhaps DORA clauses that they themselves are being presented with. So I think that kind of brings us more closely now towards the end of the webinar. Next slide, please. You can see here on this slide, this is just an overview of the really broad swathe of technology regulation that's kind of happening at the moment, and is pretty important for many of our attendees today to bear in mind. You can see here on the slide, you have the usual suspects, such as like GDPR, the Digital Services Act, the Digital Markets Act, coupled with then the more kind of newer, more topical ones like DORA, the AI Act, and the EU Data Act. We kind of have been looking into the EU Data Act at MHC more recently, quite a bit, particularly as this will largely come into effect for most firms in September later this year. And for those of you that don't know, this regulation aims to harmonise the market in the kind of digital product space, connected product space, in the Internet of Things. It will also bring about additional contractual protections for some small to medium enterprises in their contracts with larger businesses, as it introduces kind of concept of unfair contractual terms. It has, for example, a non-exhaustive list of those types of unfair contractual terms. That's kind of something we'd more typically see as well in the consumer protection space. So it's interesting that it's now been brought into the B2B perspective. So turning now to our trends and learnings. Next slide, please. And I think, Mark, if you'd like to kick us off on this.
Thanks, Caoimhe. So what have we learned from our survey from 2026 compared to previous years? So I think it's fair to say a couple of key trends here that we need to be aware of. So on the general liability caps, the survey has kind of shown us that very common to link general liability caps to fees and value, but fair to say at lower multiples than what we might have seen in previous years. So it's common to see caps at 2 times fees, but customers generally are only willing to accept caps at those levels if there's appropriate carve-outs for key risks. So for the uncapped liabilities, as a trend, still more common to see for issues such as IP and confidentiality, but there is a clear trend for confidentiality that we're seeing is that it's not as common as it used to be to have uncapped liability, particularly for contracts involving data or personal data. There's also, it's fair to say, a continued shift away from uncapped liability for data protection.
Sure.
On the indemnities, I think we spoke about this earlier. I think, Caoimhe, you're going to talk about the alignment with indemnities. So we don't see a clear discrepancy between what customers and suppliers are seeking, I think, with the exception of DP indemnities.
Yeah, I was going to speak to the significant divergence on kind of liability exclusions between suppliers and customers, in terms of what they seek in terms of exclusions from liability in their contracts. And I think, as we spoke earlier, Mark, this is particularly the case for loss of profits, loss of revenue, and loss of anticipated savings. Suppliers obviously want to carve out such losses from their liability clauses, and customers would be very hesitant to accept the exclusions of these types of losses. And then turning to the other trends as well, just the more general side, we have a definitive trend towards the use of AI and being required to advise on AI within in-house organizations, as well as the continued impact of regulation on contract terms. So speaking kind of back to that, it will be on the DORA side, we can see through the massive increase on both supplier and customer sides in implementing DORA compliant contracts and clauses in the financial firms' contract with their third-party suppliers. And as I said, just turning back to the AI trend as well, we do expect this to increase year on year as well.
Thanks, Caoimhe. So I think that might segue neatly into the AI question, which we had asked at the outset. So I don't know if we can pull that up on screen, but thank you for those of you who participated in that additional question. So we had asked in relation to the use of AI, I think 17.5% of you said yes, AI is part of your drafting process. 73% said no, but I'd like to explore using it. And 9.5% said no, I don't plan to use it. So some very interesting data there on the use of AI as part of your contract drafting process. We do expect AI to grow significantly within both law firms and in-house teams. It's certainly something that we in Hayes & Curran are exploring at the moment about how we can use it. It is, I think it's fair to say, probably still in its infancy, and teams do still need to be very cautious about over-reliance on AI, particularly for contract drafting. But there are key opportunities there. We probably see at this stage more merit in AI where you need assistance in analysing large volumes of contracts. So, for example, if you have a large number of past agreements that need to be updated, for example, to comply with DORA or otherwise, AI can be a really useful tool to help analyse and spot patterns within those agreements and recommend changes to align with your current policies or regulatory requirements. It can also help to assist organisations identify potential areas of dispute based on historical contract analysis, and certainly at this stage perhaps more useful for preventative contract drafting as opposed to live contract drafting. But it's certainly something that over the next couple of years we expect to have a dramatic impact on our day-to-day roles. And so we'll be asking a lot more questions about AI and its use in future surveys. So that brings us, I think, to our general questions and answers. And thank you. We've received quite a large number of responses. So I see there's a first question there, Caoimhe, you might want to take just on the EU Data Act.
Yeah, sure. Thank you, Mark. Okay, so someone asked, how are you dealing with the EU Data Act in your contracts? Okay, so I suppose, and some of you might remember I mentioned it a couple of slides ago, but just to give a more general overview, the Data Act introduces the concept of unfair contractual terms related to data access and use in the B2B space. And those who practice in the consumer protection law space will already be quite familiar with those concepts. But just to give you an example, so under the Data Act, a B2B contract term will be automatically unfair if it excludes or limits the party unilaterally imposing the term's liability for intentional acts or gross negligence, or if it gives the party the exclusive right to interpret a term of the contract. And then these types of terms are automatically unfair. And then we also have other types of terms that will be presumed unfair, but that is rebuttable. So those types of terms an example would be where a contract term allows a party imposing the term to terminate the contract at perhaps unreasonably short notice, or a term which doesn't allow the party on whom it's imposed to terminate with reasonable notice. But as I said, though they are rebuttable by the party imposing them, if they can show it's not unfair in the context of the particular contract. But just to go back to your question, how are we dealing with it in our contracts? You would tend to see a lot of its new requirements already addressed in many contracts. And this would typically be through the drafting of middle ground, kind of reasonable, fair notice clauses, which require each party to provide a certain amount of notice to terminate, for example. On the liability one, you probably usually would see liability for gross negligence being carved out of the liability exclusions clause anyway. So that would cover that requirement as well. Yeah.
Thanks, Viva. So I might just take a couple of the other questions there. So looking at the data that's come in, so we have a question on, some of these are hopefully knocking on the head. Does uncapped on this slide mean just subject to the general cap, thus not higher or lower? Yeah, so when we're talking about uncapped liability on the slides, we mean it's essentially unlimited liability, so it's not subject to a cap on liability. Next question, do you commonly see parties specifying what they agree will be deemed direct, indirect losses? It's obviously better to be specific and remove ambiguity, but can also really lengthen negotiations. Yes, that's absolutely right. It can certainly lengthen negotiations, but it's fair to say that it's probably more in the large scale contracts that we see parties looking to agree and document a list of direct and recoverable losses. And as I said earlier in the presentation, that's certainly a course of action we'd recommend, because that does overcome the hurdle of what is foreseeable and what's not foreseeable. So really any type of loss can be either direct or indirect. It really depends on how foreseeable it is. Is it within the contemplation of the parties at the time? So if you can agree at the time as a loss that's likely to arise, do certainly try and document that, because from a customer's perspective, at least, that makes claims much more easy further down the line should they arise. Okay, another question. Can you explain the fundamental difference between the gold standard signature and a regular DocuSign type signature? So I'm assuming we're talking here about qualified electronic signatures, which I think I referenced as being the gold standard of electronic signatures. And that's a really good question. And I suppose a lot of the major platforms have only rolled out QES signatures over the last year or two. So it's still something we're getting to grips with. But basically, my understanding of the differences between a QES signature and a traditional signature is that the qualified electronic signature requires an additional layer or additional layers of ID verification. So they're essentially equivalent to having face-to-face verification, and a digital certificate would be issued to back up that. So that digital certificate is generally issued by a trust service provider authorized by the EU, and it's generated by a qualified signature creation device. And that process, essentially, the logic is that ensures maximum security and validity. So that basically the principle is then that a QES signature is equivalent to a physical signature that's been witnessed and attested. And that's the key differences between a QES and a traditional E-type signature. The next question, what is your view, the trend on exclusive jurisdiction clauses? So that's a very interesting question. So certainly from an Irish contract, so most contracts, we do tend to see parties, both suppliers and customers, opting for exclusive jurisdiction clauses. So saying in most cases that the disputes must be dealt with by the Irish courts, and then in line with the Brussels regulations, being able to enforce that elsewhere. Some years back, it's probably fair to say that we did see more extensive use of what's known as asymmetrical jurisdiction clauses. And those are essentially clauses that allow one party to an agreement to sue in a specific court, while allowing the other party to sue in that court, or indeed in any other competent court that it determines in an appropriate jurisdiction. There has been a lot of recent jurisprudence around asymmetric jurisdiction clauses. A lot of member states have upheld them as being valid, but there was recent decisions from the Courts of Justice of the European Union that held that asymmetric EU jurisdictions are only valid under EU law in certain circumstances. For example, if they designate with sufficient precision the alternative jurisdictions in which the proceedings may be brought. So because of those increased concerns, and I think in light of that jurisprudence, probably fair to say that we're seeing a lot less asymmetric type jurisdiction clauses than we would have previously. It's not to say there's been a wholesale shift away. We do still see them quite often, for example, in certain transactions, but overall, they're not as frequent as they used to be, because parties are a little bit more concerned about whether they'll be upheld or not. So Caoimhe, I might pass back to you then for the next question. I think I see there's a question there on UK governing law, which I think covers an area you talked about earlier.
Yeah, sure. So we have a question asking, are we seeing pushback from customers on foreign suppliers wanting UK governing law? Is it Brexit issues? So yeah, so customer pushback in this respect is definitely falling, though obviously it's still there, as my slide alluded to earlier. it's highly likely that this type of customer pushback is probably, due to Brexit, which I know is quite some years ago now, but I guess is still kind of there in some ways, as well as previous market instability concerns, and perhaps not being as familiar with English and Welsh law, or the possibility that English law may begin to deviate, or was perhaps beginning to deviate from EU law post-Brexit. And that would be the reason they were pushing back on UK law governed terms. But we can see from the data that customers are becoming much more accepting of English and Welsh law governed terms, and are generally happy to go with it. That said, it is still probably under 30%. So it is increasing, but it's still quite low. And it's quite high still, as I said, the kind of middle ground where they would accept the English law and jurisdiction, but implement some kind of Irish law related specific matters into their contracts.
Thanks, Viva. Okay, just looking through some of the other questions we received in, and apologies again if we don't get a chance to get to all the questions, quite a few of them here. So the next one I see on my list is, have you ever advised on arbitration, and is it commonly used in Ireland? Is this typical for certain contract values? So a very good question. And I think it's probably fair to say that the use of arbitration clauses really does vary depending on the sector you're in. They're a lot more frequent, for example, in the construction sector. From our perspective, we do see probably more and more customers reluctant to agree to arbitration clauses, unless it's a particular concern about confidentiality. Customers will very often prefer to go to the courts. From a supplier's perspective, there may be more concerns about reputational damage if they have cases against them. On the flip side, they're looking to pursue claims for their fees. There's fast-track procedures under the courts that they can avail of. So for arbitration clauses, again, very much sector dependent. We do see them, but there is a very kind of small pool of arbitrators in Ireland for certain types of dispute. And because of that, parties often prefer the courts. And this is particularly the case, I suppose, with the commercial courts. So if you have very high value disputes for IP or otherwise, there are fast-track mechanisms you can avail of through the courts procedure to pursue those claims. And that might be a preferable course of action to arbitration. So I think as a trend, I would say we're probably starting to see more and more customers push back against arbitration clauses, more concerns about the impact of how that procedure would work. And, depending on the types of dispute, they'll weigh up as to whether there might be preferable routes through the commercial court, or otherwise it might be available to them depending on the types of claim. So I see there's also a question there on DORA compliance.
Yep, sure, I can take that one. Sure, yep. So we have a question from one of our attendees. In terms of DORA compliance, what is the general market position in terms of getting DORA compliance across the line for existing ICT contracts this year? So I suppose, as I mentioned, it's a bit of an ongoing project for many financial services entities that are within scope of DORA. And the date for compliance was in January, I think 17th January earlier this year. I suppose in trying to get, your amendments to your contracts and to your existing contracts over the line, it involves a good bit of drafting, also a good bit of looking at your existing contracts to make sure you know how you can change them, how you can vary them, what's the process and the procedure to be followed, as well as putting together contract addendums that will comply with that original existing contract. And I suppose any notice periods required to make those changes, as I said, and then putting together compliant clauses. I suppose as well, another thing is identifying those suppliers and your supplier contracts that are within scope as well. So it is certainly a bit of a project, and it does take a bit of work, but there are fairly standard terms that can be implemented to ensure DORA compliance. And a lot of our clients are certainly taking a lot of action on it as well this year, with aims to have it finalized by the end of the year.
Thanks, Viva. Okay, just coming through to some of our final questions here. So there's a question: how would you quantify a data breach in a contract? So I might take that one. It's a really good question. And it's a question which we would probably always ask our clients themselves. So, from a customer's perspective, if you're acting for a customer, we'd always ask them to look at the worst case scenario when they're trying to quantify what an appropriate level for the data cap might be for data breaches, for example. What can go wrong here if there's a data breach? So from a GDPR perspective, you'll all be familiar with potential fines, 20 million or 4% of turnover, but there's also reputational damage. It's cost to reconfigure lost data, corrupted data. And there could also be, depending on the extent of the data, significant claims from third parties. So there could be a huge amount of exposure for customers where there is a data breach, and all those issues need to be taken into account when trying to quantify what the appropriate liability position for that breach should be. And it can be a really tricky issue to get that balance right. Suppliers will argue, well, look, we're not acting as your insurer here, and we shouldn't have to take full responsibility for a data breach. For example, if a supplier is paid less than 1 million in fees, they'll say, well, look, why should we then take on exposure in the tens of millions? And, occasionally suppliers might decide to turn down business on that basis. And the parties would also take insurance cover and levels into account when assessing what appropriate level for the liability caps for data breaches will be. So it's a really tricky question and takes a lot of investigation. But certainly, from our perspective, we'd always recommend look at the worst case scenario from a customer's perspective to see what an appropriate balance for the risk and allocation of that is under the contract. So I think that brings us to the end of our questions. Thank you all very much for participating again in our survey. We really do hope to see you again next year, and we can't do this without you, so thank you again. On closing, you'll see a survey will pop up automatically on your screen at the end of the webinar, so please do fill that out, and also please highlight some future topics or trends that you'd like us to take into account for next year's survey. So thank you again for participating, and we do hope to see you next year.